the statute at issue prohibited the unnecessary killing of animals. And this necessity factor created an avenue for individualized assessments and for veiled religious discrimination because the governmental entity had the broad discretion to determine whether it was necessary or unnecessary. And this court upheld the application of strict scrutiny to that law because it substantially burdened the free exercise of religion.
But isn't this just a generalized, neutral land use law that applies to everyone in the same way?
No, Your Honor. Some land use laws are neutral laws of general applicability, such as a height restriction, where all individuals or institutions are subject to the law equally. However, many land use laws, such as the one here, give the zoning board the broad discretion to determine whether one party should be subject to the law or another party should not be subjected to the law. And that is essentially the definition of an individualized assessment. And it creates the avenue for veiled or covert religious discrimination. And because this court has said that it's appropriate to apply strict scrutiny to individualized assessments that substantially burden the free exercise of religion, our loop is simply a codification of this court's precedent.
Counsel, what's the factual foundation for 14th Amendment action?
The factual foundation?
Yeah.
Your Honor.
Where's the widespread violation?
Yes, Your Honor. Your Honor's question goes to the congruence and proportionality test. And here, Congress has met its burden in establishing widespread discrimination through both anecdotal evidence, expert testimony, and statistical evidence. An example of the anecdotal evidence occurred in St. Petersburg, Florida, where a zoning board, with the stroke of a pen, relabeled a church something it was not, a social services agency, called the church a weed that needed to be weeded out, and by relabeling the church something it was not, a social services agency, the zoning board forced the church to leave the city limits.
Yeah, but doesn't there have to be significant, widespread violations? Are you basing this on what? On the Kennedy and Hatch sort of generalizations about violations? Where are you getting the significant violations that get you to the next step?
Yes, Your Honor. Well, the anecdotes did occur in states across the United States, and statistical studies evinced widespread discrimination.
So what do they show? What do the statistical studies show?
Yes, Your Honor. One study showed that minority religions, such as Judaism, which only account for approximately 10% of all religions, are involved in approximately half of all land use litigation involving religious institutions. And this great discrepancy in the representation of minority religions in land use litigation inevitably leads to the conclusion that there is discrimination occurring in the land use context.
Why? I mean, that's a non sequitur.
Your Honor, the fact that minority religions are butting heads with zoning boards so often leads to the conclusion that the zoning boards are discriminating against these minority religions. For example,
I mean, so you say, that's ipsy dixit. I mean, it doesn't necessarily follow.
Yes, Your Honor. Well, Congress considered this evidence, and it is indeed constitutionally mandated that when Congress finds discrimination or finds any constitutional violations, that it acts in order to protect the guarantees.
Oh, but that can't be right. As Justice Lippman said, it has to be widespread. It has to be pervasive. I'm sure you saw Professor Hamilton's article that was cited in the district court opinion, and she breaks down the record. And it really was trivial almost as she summarized. There were 2 instances where there were actual reversals. There was 2 anecdotes. There was almost no record of widespread violations. So, and I think it was pointed out that there were no experts at all, and you mentioned expert testimony. Was there expert testimony before Congress?
Yes, Your Honor. Experts did testify before Congress, and there was sworn testimony of the discrimination occurring in discrete locations across the United States. But
is a sporadic event enough, or does it have to be pervasive?
Your Honor, several answers to your question. First, the nature of the discrimination in the land use context is that it is veiled or covert discrimination that occurs through individualized assessments. And furthermore, Your Honors, this court in Nevada Department of Human Resources versus Hibbs emphasized 2 very important rules that are particularly applicable here. First is that this court should give great deference to Congress in its legislative findings, and also that anecdotal evidence should be given great weight in establishing a pattern of discrimination.
What percentage of applications of this kind were not granted in the evidence that you have, that you're relying on, putting aside whether it's pervasive or a few anecdotes, what percentage, what do you have empirically that makes your case that, again, that warrants action under the 14th Amendment?
Your Honor, as Congress noted, the most common place of conflict between religious groups and the government is in the land use context. And there are many cases.
But again, are there statistics that show, that might give us a better idea of
Yes.
what the extent of this is?
Yes, Your Honor. Again, it is a discrete example, but it's very illustrative. In Chicago, 30% of individuals before the zoning board, one particular zoning board, were religious groups. And religious groups came nowhere close to representing 30% of all land users. And so again, the evidence shows that religious groups are frequently butting heads with zoning boards, and Congress has reviewed all of the evidence before it and determined that there was a pattern of discrimination and a need to enact legislation to prevent this discrimination.
You agree that there needs to be a basis of pervasive, unequal treatment established by specific proof, right?
Yes, sir.
And you agree that the basis, the record in the Congress with respect to this statute pales in comparison to the pervasive, unequal treatment that supported the ADA?
No, Your Honor. The record that supported the ADA was not more robust than the record here. There is.
You're saying it was similar to the record here?
Yes, Your Honor. Perhaps there was more evidence. However, again, the discrimination that occurs in other contexts, such as against individuals who are disabled, is easier to prove, to compile concrete evidence. And here,
I'm sorry, Justice Lippman. You've mentioned that a couple of times. Are you suggesting that if it's hard to prove it, then you don't need to prove it in order to sustain congressional action under Section 5?
No, Your Honor, but when it is difficult to prove, it is important to rely on things such as statistical studies and anecdotal evidence and sworn testimonial evidence that is given before Congress. And Congress has met its burden in establishing this discrimination, and therefore our LUPA is a congruent and proportional means to remedy discrimination because it is narrowly limited to the land use context and further limited to only land use laws that involve individualized
Follow up one more time on statistical evidence. You said 30% of this one board, the applicants were religious institutions, and I understand that. You said they're constantly butting heads. But how often have they actually been denied? I believe I read somewhere that it's about 1% of the time that the applications are actually denied. So while they may be a great percent of the applicants, where's the proof that there's discrimination?
Your Honor, the fact that religious groups have to go through the litigation process, whether as opposed to receiving a special permit based on the specifications of a building proposal, does lead to the conclusion that there is discrimination occurring in the first place.
I'm sorry, what special permit process are you talking about?
Your Honor, a general variance process or special permit process.
Doesn't every landowner have to go before the zoning board?
Yes, Your Honor, but the study shows that most secular institutions are granted the special permit or variance almost as of right.
What study shows that?
Your Honor, the Chicago study does show that. Another study.
Yeah, but you've got these land use decisions made in, every community and throughout the nation every day. Chicago didn't pretend to look at all of them.
Yes, Your